Welcome to Skybriedge, your daily dose of gripping news. We uncover bold, bizarre, and breaking stories from criminal cases to celeb scandals. Our channel isn't just reporting, but also deciphering the news with insight and attitude. Real talk on real issues with real-time updates. Subscribe and dive into the story.
Loopholes in the testimony of Brigadier Gininda in the Senzo trial. Point number 1. Over-reliance on hearsay evidence. Brigadier Gininda recounted what Kelly Khumalo allegedly told Warrant Officer Steenkamp instead of summoning either as a witness, making Khumalo's version indirect and vulnerable to exclusion. Defense counsel advocate Charles Mnisi argued that relaying Khumalo's statements through Steenkamp and then through Gininda amounted to inadmissible hearsay since none of the primary witnesses was under oath when those words were recorded in court. And then the second one is that of a video evidence which contradicted the injury claims. Gininda accepted a 2-minute ENCA clip showing Longwetwala walking without a limp the day after Senzo was murdered. I think you should have brought Longwetwala to court to come and testify, and that ankle checked by the specialist to bolster his claim that Longo was never injured. Another thing is the conflicting dockets on intruder theory. Initially, Gininda doubted any external assailants entering the Khumalo house. However, a second docket of defeating the ends of justice was opened against the occupants of the house, only for Gininda to swing back and conclude intruders were present based on cell tower pings, DNA from a discarded hat, and a ballistic results. The oscillation between dockets 636 10-2014 and 375 1-2019 revealed deep investigative splits over the case's core theory. Number 4 is the ambiguity of Ntanzi's confession process. The defense contended Bongani Ntanzi was coerced into signing a confession drafted in Gininda's presence. Gininda pushed back, claiming his only role was to collect the already signed statement, yet he could not clearly establish when or under what circumstances Ntanzi first provided it. This gap leaves unresolved questions about whether the confession was voluntary, when Gininda first saw it, and how it was obtained. There is also a witness protection gaps in Gininda's testimony. Gininda testified that a key witness dubbed Gwabini declined offer for police protection despite fearing for his life. No follow-up was made to secure his testimony or safety, depriving the court first-hand observations about the alleged intruders. The failure to enforce protection protocols even after Gwabini's expressed concern weakened the potential pillar of the state's intruder narrative. Lastly, Brigadier Gininda testified that Constable Zungu feared reporting the accused because he believed they were hitmen. However, Gininda's account largely based on what Zungu had previously told investigators, not on direct in-court testimony from Zungu himself at stage. This is considered hearsay because Gininda relayed Zungu's state of mind and observations without Zungu being present to confirm or clarify them under oath. In this instance, Zungu's assumptions were speculative and not substantiated by hard evidence. The court was left without Gininda's interpretation of Zungu's fears rather than Zungu's own account. That's all from me today. Let me know your thoughts on the comments down below. Kindly like, share, and subscribe. Have a lovely evening. Goodbye.